Once upon a time in early 20th century England, a young university student named Inman was living the life many would envy. He was a minor, not yet 21, and studying at the prestigious Cambridge University. Inman came from a well-off background, and his appearance reflected it. He was already well dressed, his wardrobe stocked with an ample supply of fashionable clothing suitable for a man of his standing. But like many young men in elite social circles, style and extravagance often called louder than necessity. Enter Mr. Nash, a skilled and ambitious tailor. He ran a reputable establishment and specialized in high-end garments for gentlemen of means. One day, Mr. Nash received an order from Inman for a collection of clothing, stylish, finely crafted and expensive. Among them were 11 elaborate waistcoats, the kind that sparkled under the gaslights of drawing rooms and whispered affluence with every button. There was no formal discussion of payment or parental consent. Nash assumed, as many tradesmen of his time did, that a student of Cambridge, dressed so well and acting so confidently, would naturally settle the bill when the time came. But when Nash later sought payment, he was met with a rude awakening. Inman refused. He argued quite simply that as a minor, he was not legally bound to pay. Nash was incensed. The clothes had been made and delivered, his craft and materials invested. Surely, he thought, the law would stand with him. After all, Inman was living like a young gentleman and had enjoyed the use of the clothes. Nash took the matter to court, arguing that these garments fell within a special category recognized by the law, necessaries. The case, Nash v. Inman, landed in the Court of Appeal, where the judges were tasked not with moral judgment, but with applying a strict legal test. The law had long recognized that while minors are generally not bound by most contracts because of their age and presumed immaturity, there is one critical exception: contracts for necessaries. These are goods or services suitable to the minor's condition in life and actual needs at the time of the contract. Nash's argument hinged on this exception. But the court saw things differently. It was not enough for the clothes to be suitable in style or quality. The tailor had to prove something more, that Inman actually needed them. That is, that he was not already adequately supplied with clothing of that type. And this was where Nash's case unraveled. The evidence showed that Inman was already well stocked with clothes before ordering more. The 11 waistcoats, no matter how finely stitched, were not necessary. They were a luxury. Lord Collins, giving judgment, made it clear: the seller bears the burden of proof in such cases. If a trader contracts with a minor, it is his responsibility to demonstrate that the goods were both suitable to the minor's lifestyle and necessary at the time. Nash had done the former, but not the latter. And so the court sided with the young Inman. He walked away, untouched by legal liability, while Nash was left unpaid for his labor and materials. The law had spoken clearly and firmly. Contracts with minors are not to be entered lightly, and those dealing with them do so at their peril. The tale of Nash v. Inman has since become a cautionary story told in law schools across the world. It reminds us that the law does not only protect fairness, it protects vulnerability. Minors, even well-dressed Cambridge scholars, are shielded from the weight of adult obligations unless what they receive truly meets a need. And for the tailor who mistook elegance for necessity, it was an expensive lesson in the fine print of capacity.